What are the penalties for a conviction of forgery in Texas? The Law Office of James Alston explains that. According to the Texas Penal Code, criminal forgery charges involve the alteration of any written article in an unauthorized manner and can include completing an unauthorized act with a fabricated document, manufacturing an original, fictitious document, acting upon the forged item, and owning a forged document with the intent to use or distribute it. A forgery case may be tried as a misdemeanor or a felony, depending on the circumstances of the case. The state of Texas penalizes the forgery of a will, deed, mortgage, or any other contract as a felony with a maximum of 2 years in prison and up to $10,000 in fines. The forgery of federal funds, such as legal tender or postage stamps, are tried as third-degree felonies and are punishable by up to 10 years in prison and a maximum of $10,000 in criminal fines. There are 3 possible defenses against a charge of forgery. The defendant unknowingly possessed forged documents. This defense establishes that the defendant did not commit forgery intentionally. An attorney may try to argue that the defendant had a lack of intent to commit the crime if the forgery was completed under an instrument of good faith, in which the defendant assumed that he possessed the authority to execute the written change to a document. Anyone who is under the influence of drugs or alcohol when the forgery occurred may be able to use a guilty knowledge defense. This defense is sometimes successful in getting a reduction in charges. It demonstrates that a defendant acted in an uncharacteristic manner because he was not thinking clearly. For a free phone consultation, contact attorney James Alston in Houston, Texas at 713-714-0481 or visit www.houstoncrimedefense.com.